Good morning, members. It is the appointed time for the meeting, and we have a quorum. This is the Bills Committee on the Electoral Legislation Miscellaneous Amendments Bill 2014. It is our first meeting, and the first procedure is to elect the chairman. Any nominations? Yes, Martin? I nominate Mr. Ip Kwok Him. Any seconder? 2 seconders. Mr. Chung Kok Pen and Mr. Yu Si Wing seconded. Mr. Ip, do you accept nomination? I do. Good. Any other nominations? There are none. Mr. Ip Kwok Him, please take the chair. Good morning, members. Thank you for your support. Now let us invite the administration team to come in. I also like to ask members whether we need to elect a deputy chairman. No? Any comments, please? If not, we will go into the agenda for the meeting. The agenda is that we are going to have a meeting with the administration on the Electoral Legislation Miscellaneous Amendments Bill 2014. And of course, we can go on to examining the bill. Attending from the administration, we have Mr. Lau Kong-wah, Undersecretary for Constitutional and Mainland Affairs, Ms. Helen Chung, Principal Assistant Secretary for the Bureau, Ms. Carmen Kong, Assistant Secretary for the same Bureau, Mr. Henry Kyung, Assistant Secretary from the same Bureau, Mr. Lee Pak Kong, Chief Electoral Officer, Mr. Sham Nam Lung, Deputy Chief Electoral Officer, and Ms. Emma Wong, Senior Government Counsel from the Department of Justice, and Mr. Henry Chan, Acting Senior Government Counsel from the Department of Justice. Welcome to you all. First, shall we invite the administration, Mr. Undersecretary, to take us through the various proposals in the bill. Undersecretary, over to you. Thank you, Chairman. To prepare for the next election cycle, we took stock of our experience in elections, and we also reviewed the various election laws. We hope that the various regulations and laws would become clearer and also would align with the statutory requirements of the various provisions. And now we have come up with this bill, Electoral Legislation Miscellaneous Amendments Bill 2014, which is going to propose technical amendments to the various laws. The technical amendments have to do with the voter registration arrangement and also electoral procedures for the electoral district councils and rural representative elections. In April, October, and November last year, we actually briefed the panel and also discussed with members of the panel these proposals, and some of members' proposals have been taken on board in this bill. The technical amendments in this bill cover different aspects. One, extension of electoral deadlines in case of inclement weather. Because of inclement weather, we will have to give people more time to complete the statutory procedures. Two, inclusion of electors who have voluntarily requested voter deregistration in the omissions list. This is to make sure that the provisional register and also the omissions list would tally. Number three, handling of applications by existing geographical constituency electors for registration in the DC Second Functional Constituency. Number four, removal of the requirement for prior notice of appointment of polling and counting agents. This is really to streamline the various requirements. Number 5, requirement for an elector to cast all his votes at one time in legislative elections. These electors, in fact, can cast 2 or more votes. We are going to require them to do so at the same time so that there will be good order in the polling stations. Number 6, rationalization of counting procedures at main counting stations. Number 7, clarification of an elector agent's authority to act on behalf of candidates. Number 8, improvement to the provisions about postponement or adjournment of an election, poll, or count. And we are talking about such being obstructed by the following. A typhoon or other climatic condition of a serious nature. We are saying that the verified period would be conducted or resumed not later than 2 days. That will become not later than 14 days of the original date. And second, that the election, poll, or count, if it is obstructed by a riot, open violence, or other occurrence of public danger, and if it is also disrupted, undermined, or seriously affected by such, it can be postponed or adjourned. And also number 9, inclusion of other minor or technical amendments that do not affect the election system. And then the bill also proposes to do something about the statutory deadlines for voting registration, and by advancing it by 14 days so that there will be 10 more days for the public to inspect the provisional register and also the omissions list, and also to make claims and objections. And also there will be 4 more days for the revising officer to arrange hearings of claims and objections. The bill also proposes to make the existing offences on making false or incorrect statement knowingly or recklessly in voter registration indictable. In other words, these will not be summary offences, so that there will not be the 6-month time bar for prosecution. This will make the law more deterrent and the enforcement more effective. I hope members will support the bill. This is my introduction, so that the relevant procedures and the registration procedures can become effective early. Thank you very much, Undersecretary, for your introduction. Members, you have read the papers. The Undersecretary has mentioned the 2 main aspects. In the first aspect, there are 9 points, and then with regard to actual voter registration arrangements, there are also some proposals. Now I'd like to ask for your views, members. Previously, we would, first of all, scrutinize the existing or present registration of voters system and also the election system. We would have a general discussion first, and then we would follow what the administration has proposed and scrutinize the proposals one by one, and then only after that will we go into clause-by-clause examination of the bill. Certainly, we should listen to the public's views in the process. I think a public hearing is necessary. Would you object to that? I don't think so, right? I think you also find that necessary. So we'll have a public hearing to listen to the views of the public on the bill. If members think that that is an appropriate arrangement, we'll get on to making it a reality. But as you know, we have very tight meeting schedules. We are totally tied up on Wednesdays, Thursdays, and Fridays, and perhaps we have to do the public hearing on a Saturday morning. I will have to find a slot with the clerk. Ms. Sito, Chairman. This is a miscellaneous amendments bill, and it covers various aspects. Deputations, political parties, and other people, including academics, who are concerned about the voter registration and election systems may want to say something, say, for example, inclement weather arrangements and also lodging of claims and objections, etc. If we just give each deputation or individual 3 minutes, they will only be able to cover one point. But this bill actually covers different areas. Now, how should we deal with this? Well, actually, even if you give people 6, 9, 12 minutes, they won't find it enough if they want to go on talking. We actually ask them to make submissions in writing first so members can read them beforehand. And then at the meeting, they should only give the gist of their views. And especially if there is a big number of deputations, it will be very difficult for us not to limit the time of speaking. And then the public hearings would have to go on end. Therefore, I think the 3-minute speaking time, well, speaking from my own experience, if you only include the gist or main points, that should be quite enough. Chairman, there are indeed several topics which are all quite important. If you really want to cover the few points, 3 minutes may not be enough. And Chairman, I hope if there would be many deputations coming, then I hope you will ask them to indicate which points they would like to address, and then we can group them together. If, for example, they would like to talk about voluntary deregistration and including the names in an omissions list, or if they want to talk about inclement weather arrangements, etc., I hope at every session we can cover one particular point of the bill instead of allowing people to jump from one point to another. It will be easier for members, the administration, and also the deputations, because the discussion will be more focused. What do other members think? If we divide it up into very detailed arrangements, again, the public might find it not easy to follow. Ms. Ho, you said that if you're going to speak on inclement weather, then we group them together. But people might speak on more than one point, so should we allow them to attend in one session or another?
So it might not be feasible. Plus, we also have an internet application. We can attempt to ask if they want to focus on specific issues. Some deputations on the marriage amendment bill, some deputations ask, why are the deputations so unanimous? Did we make any arrangements? No. We just have them speaking in order. We don't want to give people the impression that the deputations have been manipulated. Mr. Tam Yu-jung. Chairman, I think we should follow old practice. If they have a lot of views, they can provide a written submission. A lot of these people are experienced. They can manage time. If there are further views, and if time allows, legislators can devote some of their time to deputations. It's not easy to find a slot, so let's proceed. Liu Qiaogong. Well, it's hard to control the speakers and deputations, what they can talk about and not talk about. They should be given a free rein. We just want a focused discussion, because this is a miscellaneous amendment and there are some 7 or 8 issues. Well, if we don't have further views, well, the Secretary has done some work for us. The 31st of May, it's a Saturday. Could we have a public hearing? A hearing from individuals, deputations regarding the miscellaneous amendment. Saturday morning. Okay. Let's move on to the scrutiny of the bill. Let's take an overview of your topics of concern. Yes, inclement weather. Could the Secretary elaborate what the current arrangement is? Because in the past we didn't have a black storm warning. We just had typhoon number 8 warning where everything would be suspended. And now the observatory has a better estimate of weather. And even if they make a wrong assessment, the public can accept that. Well, if there's a typhoon, it won't jump from 7 a.m. There won't be a drastic change from 7 a.m. between 8 a.m. So on the voting day, if there's a black storm warning, what is the current legal arrangement? So just now I mentioned, aside from the 9 topics and 2 major issues, I'd like to handle other topics. If there are no other topics, then we might, as Ms. Sidho suggested, she has raised 1 point. We'll go through each point. So I just want your agreement on discussion protocol. Should we enter a topic-by-topic discussion? Mr. Liu Chengguang. Well, we should go through the different topics. After that, we can also elaborate on other issues that legislators are concerned about. Mr. Yu Siwing. I think it's better we go topic by topic, so we won't be jumping around. It won't confuse us. Well, if we agree, then I'll conform with the majority view. Well, Ms. Sidho wants to deal with inclement weather. Secretary, on the first issue, we do have some registration limit or time deadlines for handing documents. It could be a working day, and if it's the last working day, and if gale, storm, or black rain arrangement isn't in place for last-minute submission to submit their application or registration. So we need to amend the bill where if there's a gale or black rainstorm warning, we will postpone the working day by 1 day to allow those who wished to submit their entries on the last day, they could continue their application on the next working day. Ms. Ho? Well, I'm focusing on the 8th item, that is on the election day. But if you want to go through these issues one by one, I agree we can be more focused. I'll have the Secretary explain to us on, let's say, on the election day, halfway through the election day, there's a black storm warning. How should that be handled? Mr. Chung Kwok-ban. Well, the Secretary just said that if there's a typhoon signal 8 or black rainstorm warning, the working day could be postponed. Well, I went through the documents, and if 3 p.m. there's a black rainstorm warning, and it would be postponed to the next working day, and they would continue at 3 p.m. So I think it's the same for application registration. Some people want to register at 5 p.m. and so if they're postponed one day, they are given an extra day to prepare. And if there's a black rainstorm warning at 5 p.m. and if you continue the next day at 5 p.m., well, our intention is to provide a whole working day. So it's a black rainstorm warning at 3 p.m. So it would be postponed one day. They would continue at 3 p.m. Yes, there's extra time. Chairman, as long as it's applied uniformly, there shouldn't be any inequity or discrimination. Mr. Yu Siweng. Well, we're all familiar with black rainstorm warning. It affects the whole territory. But for gale storm, in the past, it was very rare that it would lead to traffic or work problems. So if a gale warning, that is typhoon signal 8 or 9, and also landslides. Some areas have heavy rainfall and have landslides. They can't. The voters can't leave home if there's a landslide warning, or if there are actual landslides. Would that also be a consideration? Chairman, if we have isolated areas affected, then we won't have the whole territory responding. We're not talking about weather and heavy rainfall throughout the territory, and if there's a clear signal, we will have an immediate postponement. But if you're talking about landslides in one region, in one district, it will not postpone. But it might affect some people. These people could put forward their reasons, and we'll have to see how the EAC would respond. But we will not postpone the whole procedure. Well, so my understanding is if there's a landslide or flooding in an area, let's say a village, that has occurred before, so the EAC would consider that district or that region, or the voters in that area would be given a postponement. Well, for any emergency, if they are intent on applying or voting, they can put forward their reasons, but it won't be applied throughout the whole territory. Well, that landslide or flood, it's related to weather. So if there are regional flooding, it would affect people. So why can't this be handled? Well, our amendment is targeting a comprehensive situation. So if we have local problems, emergency issues, it should not affect the whole process. But is there any written provision? Who will decide this discretionary handling? Well, it seems it would depend on the responsible officer to decide whether they could continue voting. We're not talking about voting. We're talking about registering or application, just handing in documents. Chairman, it does not depend on individual judgment. This amendment targets gale warning and black rain warning. The observatory has very clear, objective announcements. So once there are announcements, we will activate the postponement. Well, there are also warnings for landslide and floods. Mr. Liu Chonggong, do you want to follow up? No? Should we consider this? You see anything to follow up? Well, since we're dealing with this provision, shouldn't there be additional description? So there are some guidelines to follow, because it's ambiguous right now. Since we are drafting the law, why can't we make it clear? Priscilla Leung. Recently, we have seen hailstorm. I was driving during the hailstorm, and I was stuck in traffic. And this might not occur in other districts. I see gale storm warning, tropical cyclones. Well, could we also add the clause, an act of God? Legally, we have a lot of cases regarding acts of God. So, if you have an act of God in a certain district, that is something. So, let's say a whole district is affected. Couldn't we have a better standard? Even if you ask your legal advisor to assess, well, a lot of people are affected in the district, but people in Kowloon are not affected. So you could handle a whole district. I agree that they all face the same situation, so they might really have some events occurring that are different from other districts. So I suggest that could you consider this, adding a category where in the future, when this problem is considered, there are more guidelines to follow. Well, since different legislators have raised this question, we'll go and reconsider this. Yes, you can consider acts of God. This is something that is used very commonly, even in the courts. You can try to handle this administratively or through other measures. Well, Chairman, we have some procedures that can be done electronically. These are updated very frequently. So could the Secretary elaborate on electronic submissions? So aside from weather affecting a person, well, let's say if you have an internet application, could Mr. Lee clarify? Let's say you got hacked, the EAC system got hacked and people can't log on. So what about procedures on the internet? We're talking about registration during the electoral process. As far as I know, registration cannot be conducted electronically or through the internet.
On the contrary, you can still make the declarations afterwards. Now I'm looking at the background information paper. It says something about the deadline for voter registration, that you can do so online or by fax. Can you comment? Thank you, Chairman. Mr. Lee, in the present registration procedure, most acts can be done electronically. Apart from what the Chairman pointed out, some procedures, for example, the submission of the nomination form, that must be done in person. But notices or notifications, etc., those can be submitted electronically, including what Ms. Ho mentioned. The advertisements, for example, we have already set up a platform for candidates to submit a copy of the advertisements. One of the ways to do submission is electronically, or you can do so textually, or you can do so by fax. So, Chairman, I'm asking this. What about there is a power failure? Will that be accounted for? You are saying that if inclement weather prevents people from coming to you in person, so there will be postponement for 1 day. And also if the online system is hacked, would that be postponement as well? Or are you saying that if there is an online problem, people can still come in person? Mr. Lee? I was saying that electronic submission is only one of the ways. We, of course, will ensure that the electronic platform will operate smoothly. But then if there is a problem, candidates and voters can still use other ways to make submissions. In the present law, there is no particular provision to say that if the electronic platform is obstructed, there will be a postponement. There is no such provision. And my view is this is only one of the ways to do it. And there are many more ways to do the same thing. And we are talking about a deadline. It's only when this happens at the deadline, then we have to consider a postponement. Chairman, some rights should be treated leniently, especially voter registration. Whether there is vote rigging, well, you can investigate if there is such a case. But if it is bad voter registration and people live in a remote area and they don't want to come in person, however, if there is anything wrong with the online system, then I hope you will have flexibility. I will ask you to consider this. Mr. Lee, Chairman, can I add a point? The amendments this time around is based on one major consideration, and that is under present laws, there are deadlines controlling different acts. In Cap 1 of the laws of Hong Kong, there is a postponement arrangement. It says that if by a deadline there is going to be a typhoon number 8 or a black rainstorm warning, then there will be postponement for 1 working day. However, in the present laws, very often the wording is different, and therefore Cap 1 at present does not apply to many electoral laws. We discussed with the DOJ and we think that the situation is not ideal. We did not meet up with any difficulties, but then in the future, as you know, weather cannot really be predicted, and this might just as well happen. That is why we are saying that we are going to introduce this arrangement, particularly for electoral laws, so that we align with Cap 1 and the spirit therein. And that is, if there is a gale warning or typhoon number 8 or above and a black rainstorming warning on the last day, then we would have a postponement for 1 day so that the law is more comprehensive. But of course, members are saying that there should be flexibility. But then in attending to electoral procedures, we have 2 major considerations. One, that the system must be predictable, that it should be proper because it has to be legitimate. Secondly, we would also like to have flexibility to deal with different scenarios. However, we have to strike a balance between the two. And our present amendment is really to apply Cap 1 to the electoral laws. Chairman, I understand. I understand that electoral procedures must be very strict and regular. But then when a VR has submitted a form, you still have to check it and verify it. And as you know, voting rights and standing in election rights are very important rights. So please think about this online registration of voters. I understand many people are doing it online or by fax. I hope you will look further into the matter. In other words, you are talking about a breakdown of the online system. Is that right? I hope the administration will consider this point further. Perhaps Mr. Lee can let us know how many people do VR in person. I think there must be so few. I think many more do so online. Mr. Lee, experience tells us that very few people come in person. Most of them do so by fax, or some organizations will do the publicity for us and they will come back with some forms. And also, there are not too many using the online system. So if most people use the fax, the probability ratio of the fax system breaking down is very small. Yes, there may be some inclement weather, but in terms of the receiving of voter registration forms, we have never had any difficulties at all. Okay, on the same point, Ms. Emily Lau. Thank you, Chairman. I have a question. Do you have a mechanism for appeal? You're talking about inclement weather, and there is postponement for 1 day, but still, he cannot get registered. Still, it is his wish that he be able to submit the form, would there be a chance for him to explain why he was not able to submit the form so that he would be allowed to in the end? Undersecretary or Mr. Lee? Yes, there is such a mechanism. No matter for what reason, the weather, the collapse of the online system or traffic congestion, if he has a reason to believe that he should have been able to submit the form before the deadline, but in the end we were not able to process it and his name is not in the provisional register, then according to the present law, he can make a claim within the claims period. And the revising officer will make a decision as to whether he has a reason and then to decide whether his voter registration will be accepted. There is now a very clear procedure for such requests to be made. Okay, this is about VR, but what about candidates? Both, actually, we are talking about both. I think candidature is even more important. Candidates would like to submit a form so he or she becomes a candidate, but for whatever reason, weather or whatever, that was not done. So there is a procedure for him to make an appeal as long as he has good justifications. Is that right? If there is, within how many days? Mr. Lee. With regard to nomination of candidates, there is a nomination period, and people have to submit the nomination form in person. That is provided for in the law. If there is any reason at all that somebody was not able to submit the form in person, then he could only make an election petition to challenge the fairness of the election. And within the nomination period, he has submitted the form, but in the end, he is ruled to have submitted an invalid nomination. Then again, he can resort to filing an election petition. The law is very clear here. The law must be specific and about the various procedures. And if you cannot submit the nomination form in person for whatever reason at all, so that the election officers can adjudicate that you have submitted a valid nomination, then you can only resort to petitions. No, I'm not talking about election petitions because it's a major issue. You are now amending the law to provide for inclement weather and postponement by 1 day. But I'm talking about scenarios where people are still not assisted, even by this new arrangement. Would there be an easy way for them to prove that he has a good reason for appeal? Now, people can only resort to election petitions. Now, if the bill is carried, there won't be a problem anymore. No, I understand. But you are saying that this may be helpful in certain situations, but not in others. But what if there is a really complicated situation that people cannot submit the forms? I'm asking whether there is a convenient way for people to give proof of the valid reasons. But now you are telling me that we can only resort to election petition, but that is actually a very momentous task. So there is no way for people to give any justification. Is that right? Mr. Lee, this postponement arrangement must be free of controversy and reliable. If for some reason some candidates could not submit the nomination form in person in time, maybe because of traffic congestion or family matters, I think that would be very difficult to establish these as objective scenarios, especially in the eyes of the public, and also for the REO to accept that as a reason. So if we want to have cover certain situation, we must be able to dictate or state its objective elements, or else we would be questioned by the public. Well, I understand, Mr. Lee, Mr. Chairman. I'm just asking whether what I said happened in the past. In other words, for whatever reason, people failed to be nominated and they indeed lodged election petitions. My memory tells me that there have been none. Rather, the nominations have been adjudicated as invalid, and then there was an election petition. That happened, but I have not heard any cases of exceeding the deadline. All right. Any other questions on this point? Any other comments or questions? If not, we can go to the next point. Mr. Martin Liao. Okay, next point, inclusion of electors who have voluntarily requested voter deregistration in the omissions list. Okay, members, any questions? What is this point about, please? Undersecretary, can you give the details? At present, there is a mechanism for voters to request deregistration. This is about voluntary deregistration, so they will not be a voter anymore. But then there is another mechanism, which is the omissions list. This is done by the ERO on his own initiative, or Electoral Registration Officer. In the past, some voters voluntarily deregistered, but then they were not included in the omissions list. So there was inconsistency. We are proposing this amendment so that those who apply for voluntary deregistration, their names will appear in the omissions list. So everything is tallied with the other. Ms. Sit Ho and then Mr. Felix Chung. Some Kaifongs told me that he did not ask for deregistration, but at the polling station, he was found not to be in the voter list. And he, of course, scratched his head. He did not know why. Can the Undersecretary explain to us the mechanism? The omissions list should include people who are suspected of vote rigging. For example, there are many people in the same household with many different surnames. But how do you verify that the deregistration was actually requested by the voter himself, that he was not impersonated? Mr. Lee, omissions list, that would include two types of people. One, after our inquiry, we find that some people are no longer qualified as voters, and two, people who have passed away. For the first category, there is a statutory inquiry procedure. First of all, we would contact these voters to see whether we can track them down. Is it that they have moved house and just forgot to update the address? If that's the case, we'll update the address. If there is no way to contact them, then according to the law, we must launch a formal inquiry. We will send a registered letter to the voter to ask him to submit supplementary information. If that cannot be done, we will tell him that his name will be in the omissions list. And then if there is no claim lodged after that, then his name will not appear in the next voter register. That is as simple as that.
If we don't receive further information to confirm their voter status, we will not include that in the next voter list. So currently, our amendment bill, according to our past experience, some people had written in and wanted to deregister. They might have migrated, they might be elderly, they don't want to participate anymore. And every year we have 100 odd 200 cases. According to initially we had not considered these type of people, but in fact these people appear, and if they're not in the provisional list, if they're not in the deregistered list, then they would have disappeared. So the set of information is not complete. We want to, the goal is to have a complete set of information. So we want these people to be in the deregistered list, so other people or these people can know that they would not appear in the formal voter registration list. Ms. Sid Ho had received this kind of complaint or inquiry why they have lost their voter registration status. Well, of course, they did not put forward their deregistration, but the majority might have been because they had moved house. We had launched an inquiry and they couldn't contact them. If they have a phone number, we can call them. If they don't leave a phone number, it's very hard to update their information. So they would be, the end result is they will be put in the deregistered list, and we're just complying with the law. I want to add, the Guy Fong said that it was a district council election, and they were moved to the other district, so they could not. This is a case that was related to me. Was it because the district boundaries were drawn up? Otherwise, it was an old district, North Point, and the guy told me that they were moved to the next district. But the Legislative Council elections, unless you move from Hong Kong to Kowloon, Kowloon to New Territories, you can still cast your vote. But at district council elections, I'm concerned how you confirm their identities. Chairman, we would like to confirm this information, but we just weren't able to contact these voters. If we just have an address and no phone, or if we have a phone, they might have changed the phone number. So there is some difficulty. Of course, I believe the majority of cases were voters registered a long time ago. For new voters, they would have email address or more than one phone number, and these can be successfully contacted. But no matter what, we now have a deregistered list, and before we publish this list, we have attempted to locate these people. I mentioned that we would issue a registered letter, but if we still can't contact the voter, then according to the law, all I can do is to put them in the deregistered list. Well, in the government APIs, they tell people that if you moved house, you need to notify the ERO. You should tell them the outcome. If they don't do that, they would be removed from the voter list. Yes, if you have a specific case, we're willing to follow up. So in your APIs, you need to tell people if you don't update your information, you might not be able to vote. Mr. Chung Kok Man. So, being placed on the deregistered list, the Chinese word placed, it is a government initiative. They have discovered a person, and here we're talking about voluntary deregistration. So if you put the two categories together, you can't tell whether it was voluntary or was it a government initiative. Well, if we're going to categorize, why don't we have a voluntary deregistration rather than being placed under deregistration? That would be clear. I voluntarily deregistered rather than being placed in a deregistration list. Well, Mr. Chung has identified a very minute subtle difference, but we want to have a simple procedure. We want a list, a voter registration list, and a deregistered list, just two sets, and suggesting a third category. We feel it's not it might not be that necessary, and being placed under deregistration, well, the effect is not that different. Because the outcome is the same. I don't quite agree with the Undersecretary's explanation. If you want to clarify, having distinct categories clear, yes, of course, you are ultimately removed from a voter list, but the intention, the clarity, is not as distinct. Being voluntarily deregistered and being deregistered. Well, for those who have taken the initiative to voluntarily deregister and being deregistered seems to be a difference. Perhaps the government could reconsider Mr. Yu Siwing. Just now, we heard there are only some 100 odd per year who voluntarily deregister. Well, I think there must be reasons for deregistering, but the government here says that they can reactivate their status. Do they need to put forward any reasons? Otherwise, it doesn't feel very stringent. Well, they could deregister and register again. I think it should be a formal process. Shouldn't they state reasons for registering again? Undersecretary, the voter registration is voluntary, and we want to encourage more people to register if they have reasons for deregistering. On the third point, we might be able to clarify this. They might have other reasons for reactivating their status. We welcome them. But if we require them to put reasons, that might not be in line with our old policy of encouraging more people. Of course, I understand you want a formal process. You don't want people to abuse the process. But we do allow them entry and exit as long as they fulfill procedures. Well, I think it's a right. I can exercise my right, and I can voluntarily deregister. If you require reasons, it might be some restriction on exercising a right. I know it's a formal process, but it's a right, Mr. Yu Siwing. Well, when they deregister, they don't need reasons. Well, okay then. Mr. Tam Yu Zhong. Well, our system is voluntary. If you want, you can register. If you don't like, you can deregister. Unless you don't need to register. We don't need to register. As long as you're eligible, you don't need to pre-register. We also have mandatory systems. So I don't think that's a big issue regarding deregistering and being deregistered. I also agree there are two categories, but perhaps out of convenience sake, they are grouped together. Well, there might be some feelings about voluntary deregistering. Well, we now have found that there are some samples being taken by the ERO, and they issue letters. Well, the elderly, when they receive these, they might not understand the letters. They don't know how to handle it, or they just discard it. So voting day comes, they find that they have been deregistered. I think this occurs very frequently amongst the elderly. And I've heard Mr. Lee say that if they have a phone number, they can be contacted. So, well, if you ask them to visit them at home, that would add to your workload. So we do have problems with the current arrangement. But I feel it's hard to make any improvement. But a lot of elderly they don't know how to handle these type of letters, and they just ignore it. That's why if you say a lot of people are deregistered, and a lot of people say, how come I'm not allowed to vote? Perhaps we need to address this problem. Mr. Lee, I just want to add one point. Starting from 2012, we had a series of auditing procedures. We had random samples and targeted investigations. For example, the building is demolished, or we have many surnames in one household. The other measure is a random sample. So I understand Mr. Tam Yu-jung, and I agree with his view. Basically, in our actual work experience, these scenarios occur. Some people, they have been chosen randomly, and they are very frustrated when they receive this letter. They have exercised their rights, they have undertaken their duties, and they're utterly frustrated and drop out. So it's a balance. Random sampling shouldn't be done on a large scale. In 2012, there were a lot of reports. False addresses were used to register, so it was necessary. But later on in review, we need to strike a balance, because random sampling, it is somewhat contradictory to our voluntary registration intention. We need to have sufficient deterrent effect. So in our future measures, we need to fine-tune the process. I want to follow up. Recently, a certain district, they found vote fixing. So will the ERO investigate vote fixing, especially on the eve of voting day? Yes. If the media report this widely, aside from the voter registration office following up in the past, we would target the complaint. You can't just say that within a certain building all data is false. For example, in a recent district, we had contacted all the voters after initial confirmation. We reminded the voters that under certain legislation there are things that they need to bear in mind. Of course, it depends on the situation. If there is time, we will follow up case by case, but we will remind the relevant people if they provided false information, and if they deliberately voted when they knew they were not eligible, they would have to bear the legal liability. Will you also notify the public that it seems that the media have reported this vote fixing, and the public have this sentiment? So has the ERO followed up to clarify?
Yes, indeed. We have that responsibility. Actually, we issued a statement the day before last to detail our follow-up work. We have already given an account of our initial follow-up work, and we have said that the addresses were not detailed enough. And actually, we do not see prima facie evidence to show that some people have filed false addresses, but some addresses indeed are not detailed enough, and we are going to do follow-up. But you will understand that in old districts and old buildings, there is not just one way to write the address. There is no uniform way to write the address, and it is possible that the same address can appear in different ways. And we have got verification from the post office that they can deal with the various forms of the same address. So if an address is questionable, then basically if the election or polling form is sent back to us or returned to us, then we will certainly follow up. So somehow, if there is a different description of the address, the public may have the question as to whether it is a false address. We'll certainly follow up, and if there are initial results, we will inform the public. But then we'll have to strike a balance because this is a complaint, and it has referred to the EAC for processing, and we have to protect people's privacy. And we will act on both fronts. But as you know, the election is just around the corner, and we will watch the situation. If we have more information to divulge, we'll do so in order to allay the public's fears. Ms. Emily Lau. The administration said that this present proposal is to allow the two sets of information to be tallied. I agree, but after that, is there any particular function that can be achieved? Some members have mentioned vote rigging, which is a very big concern, and the Democratic Party has always said that you should leave no stones unturned when you do the investigations. Whatever has been effective should not be given up. Of course, I know you have to strike a balance, but you have to do your best. In 2012, you removed 200,000 voters. Please comment on that. These two lists are for public inspection, right? So what kind of effect will this present amendment achieve? How can you assist the public, voters, and candidates to understand the situation? And one of the functions is to prevent vote rigging. Is that right? Can you explain, Mr. Lee? Chairman, I think that this particular amendment will achieve two effects. One, to enhance the transparency of the entire system because all information would be laid bare before the public. Two, the procedure itself will be made more proper. Say, for example, A will propose the registration. We've got the information. Then we'll contact A and issue a registered letter to him that he will be deregistered. But in a certain situation, A may be forgetful, and he might think that he is still on the VR, and then when he goes to the polling station, he finds that it has been deregistered. But if A's name is not included in the omissions list, then he will have ample opportunity to check the OL. And if he doesn't see his name on the list, then he can make a claim, and if the revising officer agrees, he will be registered again. So no matter why people request the registration, the present amendment will make it fairer. Because for any reason, if his name is in the OL, he will have the grounds for a claim. When is the OL issued for public inspection? Mr. Lee. Chairman, the OL and the PR are made public at the same time. There will be an amendment to amend the VR dates. But before the dates are amended, if it is a non-election year, we would issue those two lists on the 15th of June. If it is a DC election year, it is the 15th of August. Chairman, it used to be that those who ask for voluntary deregistration will not be included in the OL, so they do not know that they have been deregistered. Well, of course, they have done so voluntarily, but they may be forgetful. Now, did they raise any issue with you because of that? Mr. Lee? I have been with the REO for just 2-3 years, but I have not seen such cases. As I said, every year, on the average, there are just 100 to 200 cases. It was only in 2012 that there were more. There were 1,800 who asked for voluntary deregistration because we did some verification exercises. In fact, the number of cases is not big. Ms. Lau asked the question, and according to my memory, that did not happen. Chairman, you said that those who voluntarily deregister can ask for activation of registration. That I agree. What about those who are deregistered by you? How can they reactivate registration? Well, Mr. Lee, I will have to see how the claim is made. Before his name is in the OL, we would have already done the statutory inquiry, we would have asked information and he did not give it to us, or the information was not satisfactory. So if he lodges a claim, we will have to get all the relevant information from him, and then we'll take it to the revising officer, who must be satisfied before his name will be registered again. Mr. Tam Yu-jung mentioned the recent news report. Some people say that it's a vote rigging, and you said you would investigate. Now the election has not been done. How can people rig the poll? Is it that those people who have the information should not blow the whistle after election day? If these people cast a vote, then there would be a vote rigging scenario. So what do you propose the public to do? Or else you would have alerted these people, and these people will not cast the vote. So how would you tell the public what to do in such a scenario? Mr. Lee, under the law, there is no definition of vote rigging, but whether it is a news report, whether political parties divulge the information, I think vote rigging is about two scenarios. One, if you provide a false address for VR, that is a vote rigging case. And of course, if that person votes on polling day, then the situation becomes more serious. So if there hasn't been an election, there can still be a vote rigging case in that people would provide false information. So he is registered for a certain district. And according to the legal definition, that is already vote rigging even before a vote is cast. Both cases would mean a contravention of the law. And if a vote has indeed been cast, it should be reported to a law enforcement agency. Now, of course, if you provide false information to do voter registration, you should report to the police. And then if this person also casts a vote on election day, then you should report to the ICAC. The division of labor is clear. I would say, therefore, if this happens, no matter what happens, the person who knows this should report to a law enforcement agency for immediate action. That is the best way to do it. If you go through the REO and the EAC, more time will be needed. Now, of course, we will do initial verification. But if you really have the evidence that there is a vote rigging case, you should immediately report to law enforcement agencies. Chairman, there are two separate offenses. But if these people eventually do not vote, then you can only suspect them for providing false information. But if you are arrested and you do not actually live there and you provide false information and then you also vote, then it's more serious. However, if you already blow the whistle, does it mean that the administration still proposes to the public that they should blow the whistle? Because, you know, those people who are breaking the law will be alerted. Don't you think that is problematic, Mr. Lee? No, I'm not saying that they should tell the media. If before the election it is found that some people make use of false information for VR or for doing publicity, that would, of course, constitute a breaking of the EAC regulations, and the enforcement agency would be the police. So you should report to the police, and the police will not divulge the information to the media. After election is conducted, if you suspect that some people have got a polling ticket in order to cast the vote by making use of false information, if you do have the evidence, then you can refer it to the ICAC for action to be taken. That arrangement is very clear. Very often, you don't have to alert the media. But Hong Kong is a free society and people are free to do what they want. But operationally, the best way to do it is to refer it to the law enforcement agency. Second round, we have Felix Chung. But at this juncture, I'd like to use my time to ask a question. I do agree that on vote rigging, before people cast a vote, how can you call it vote rigging? It would just be about false information or false representation. But as to why this is happening, I think you need to check on the complaint. But my question is based on a viewpoint. Can you clarify this? When you did a sampling exercise and there was no reply, then you already have a mechanism to send a letter again by registered mail. And after that, if you still do not get any reply, then you will omit him from the register. Now, I think that is a better guarantee for the elderly. The elderly may not know what letters they are receiving. They would just put it aside. But if you send another registered letter, then the elderly people will be alerted, and I think that's better. But recently, I got this case. That person has always been a voter, but suddenly he saw a letter addressed to him in a letterbox, but then the flat number has been changed from flat A to flat B. He just picked up the letter, and then he asked me what should be done, and I said, of course, we should refer it to the REO for an amendment to be made. But this is a real case. If he had not been attentive, he would not be able to vote again. Even if you send a registered letter, the registered letter would be sent to the wrong address. But that person has always been a voter. Now, how can this person's voting right be protected? Are you aware of that? This is an actual case, and I can actually refer it to you. This is an administrative error on your side. Chairman, this is an individual case, and I will not speculate on it, but I welcome information for follow-up. Experience tells me, however, that we have not got such cases before. The only plausible explanation is that somebody was trying to change people's address. But then if you want to change your address, you have to go through a very strict procedure, and you have to supply an application form with all the particulars of the person, and then we'll send back a letter to say that your particulars have been changed. We would have to complete that procedure before we would change any registered information on the voter register. But then if this happens, please go to the REO. That has been done because your registration is reaching a deadline already, right? But that actually happened.
Of course, we would have to follow up, but this wrong address scenario, this has occurred. So how do you ensure that this won't happen? Because even if you issue a registered letter, it doesn't resolve the problem. So I encourage the affected person, they have updated the address, they need to provide the details. We'd like to understand the whole case. If there was a deliberate attempt to change a person's voter's particulars, then we might need to add the penalties. But the question is, can we restore the voter's status, the voting rights? Well, they can't do it on the spot, but if they never received information and they launch an inquiry, and then they would find that the address was wrong. Do you have such a mechanism? Well, if we have a formal voter registration list, that cannot be amended. Well, do you need some flexibility? It is perhaps a typographical error or a work error. So you cannot deprive a person of his voting rights. You need to consider this. We need to study the case and see what measures we have to handle that. The deregistered list, does it include the functional constituency voters? Chairman, it includes the functional constituency. All the voters include individuals and institutional voters. I want to now talk about vote fixing and vote rigging issues. In the textile industry, I have handled complaints. We are the textile industry, and I've seen institutional voters selling red wine, but we are the textile industry. And I've also seen a soccer training company. I have lodged a complaint, and the reply I received was that they were eligible to vote in my constituency. But you can see they are not in our industry. So I know how I don't know what the explanation is. An investigation was launched. Mr. Lee, functional constituency registration are different from geographical constituencies. If they are designated bodies or members of associations, they are eligible to register. Every once in a while we hear cases, companies belonging to one industry, but for some reason they might have changed industries. But if the company registration is there, then according to the law, they are eligible. So even after they change the nature of business, they're still eligible. Under the legislation, as long as you belong, as you're a member of a certain association, you are eligible to register. So if this body have not changed business registration articles of association, they are still in compliance with the law. So we are just complying with the law in handling voter registration. Well, these are loopholes, very obvious loopholes. You can't say that is the legal requirement, but in fact the company is not engaged in that business. Well, you should plug these loopholes, Chairman. Mr. Lee, have you considered this? Well, it's not operational, it's a policy matter. Previously, on functional constitutions, there would be some further considerations. Before major elections, we will make amendments regarding functional constituencies, and we can see how we can handle that. Well, this is very useful information. We will investigate. Well, this loophole, the whole functional constituency is a big loophole. We should abolish it. Chairman, you received reports. Another functional constituency. They also have vote fixing, vote rigging. They are planting members before the deadline. If you have 90 companies, they can all join, and there are votes there. How are you going to plug that? Just now, we talked about issuing registered letters. So those who are deregistered, will they be notified as well? And being deregistered, well, there must have been a problem for them to be deregistered. Will there be more notices? Will the rest of society know that, see, these people have been deregistered? We will issue a registered letter. People on the deregistered list, they will first receive a registered letter saying that they will be put on this list. So before we issue a provisional voter list, we do have some notices. We have these two lists for whatever reason. These people will be put in the formal voter list, and another group will not be put in the voter list. There will be opportunity to peruse the contents of these lists. Well, I'm asking, will you do more C after we have hundreds and thousands of people who have been deregistered? So they should be warned that they shouldn't abuse the system. We always ask you to tackle vote rigging, vote fixing. Well, since you've deregistered so many people, shouldn't you take the opportunity to do more civic education? We remind voters to register truthfully. I understand Ms. Lau's concern. We'll see how we can broadcast this message. Well, if you just, and the normal APIs are not focused, but if you tell people we have 4,000 or 50,000 people are deregistered, we encourage you to register, but do so honestly and truthfully. I think that would have a bigger effect. In the past, I have not seen that spin, that perspective. In 2012, did you ultimately deregister 200,000? Well, we had deregistered 210,000. Oh, that's big news. You must have valid reasons for deregistering people. If there was a mistake, they can reactivate their status. But the functional constituency I talked about, you've seen the news. Is that a policy? Because they are not voters. First, they become members of an association. Then they have an entrance ticket, and they rig votes. How does the law handle that? Well, Chairman, we have media reports. I believe any registering, whether it's a functional constituency or a geographical constituency, we encourage that. Of course, when the ERO receives a registration, they will handle it according to the law. Well, I think the administration, if they're aware of that, they should follow up. Do we have vote rigging? Secretary, are you aware of this? When the ERO receives these registry applications, they need to conduct some auditing and reviewing according to the law. Well, this is a big loophole. It should have been excised completely, rather than plugged. Well, the deregistration list, how do you disclose this? So even for the provisional list, there are addresses. There are two ways of handling it. Will you do this in the future as well? Well, because we have a lot of people with the same last name and first name. So how will you disclose this information? The disclosure includes address. Are you referring to listing according to address? We don't have this arrangement. There is such a list in the provisional list. They are arranged by last name strokes. Well, this is slightly different from the provisional voter list. Can they check this information on the internet? Not now. Chairman, you are aware that we have explained in the panel we will promote an internet system where they can check to see if they are on the deregistered list. So once the information is input we will have a reminder letter telling the person they are on the deregistered list. They need to issue notice of claim if they want to reactivate the status. Can you do that on the internet? And you just need to input your particulars. In the past, they had to go to Home Affairs Department. Who would go to Home Affairs? You have a 9-to-5 job. You can't take the time to do that. Well, we need a channel. Miss Emily Lau had referred to disclosure of the deregistered list. Well, it has to be convenient. It is inconvenient to look for a deregistered person and so on. So in the next cycle, we will have an internet service. They just need to input their ID number and name. They can check all information, whether they are on the provisional list, deregistered list. They can check the relevant information. Okay, so item 2, inclusion of electors who have voluntarily requested voter deregistration in the omission list. We now move on to third point, handling of applications by existing geographical constituency electors for registration in the District Council second functional constituency. In 2012, there was a new FC, that is the District Council second FC. The district voters, if they weren't in the traditional FC, we would place them in the DC second FC. But some people didn't want to be this voter. They only wanted to be geographical constituency elector. And they applied for removal from DC second FC. But now they wish to re-enter, but the current law doesn't allow them to enter the FC. So we need to amend and allow entry into this FC. So theoretically, a voter, either they are traditional FC or the second FC, that is the super district council voter. Well, if they're willing, they are either one of the two, the traditional FC or second FC. But in fact, in the 2012 elections, I personally had 3 votes, 1 GC, 1 in my FC, and the third vote was the second FC. So I had 3 votes. Well, was that possible? But I did have that, and a lot of my friends also had that status. Who can answer this? Mr. Lee? Well, if they are a voter in the second FC, then they could not register in the traditional FC. So, if you have 3 votes, then you are an authorized representative in the second FC, then you would have 3 votes. Mr. Chong, can you clarify this? Well, yes, you are aware. We have in the textile industry, we have institutional voters, and I would have 3 votes.
In other words, you have been authorized. If you have a corporate vote, you don't vote as an individual, but you vote on behalf of the corporation. We're going to preserve that. Is that right? Mr. Lee? Yes. There are about 14,000 to 15,000 people who have 3 votes because they belong to a traditional FC. They could have been authorized to vote, or he can also be a voter in another FC. Mr. Chung. Chairman, some friends have 4 votes actually. Why? A GC, first of all. Secondly, authorized by corporate, 3 professional bodies, and 4 DC second FC. From what I understand, that is not possible. Mr. Lee, can you answer that question? The law will not allow 4 votes to appear. If you are a professional, if you are already an individual voter in a certain FC, then you will not be a DC second FC elector. In other words, we would only issue at most 3 votes to 1 voter. Would there be some confusion? Chairman, I would take up that case and refer it to Mr. Lee, because as far as I know, that is impossible. I have been following the electoral laws. If you are in the DC second FC, then you will not have a vote in another FC. That is the law provisions, and you were told to transfer to the DC second FC if you so choose. Okay, we will not dwell on that case. Ms. Sit-Ho and then Mr. Chen Kam-Lam. Chairman, the corporate votes only represent that an individual is voting on behalf of an organization. Of course, we object to it. We want an amendment to be made, but still allowed by the law. Mr. Phyllis Chung said that there could be 4 votes. Well, I believe there must be a computer problem. I think Mr. Chung will not be inventing this just to challenge you. But if that was really a case, then it is clear that the register of voters has become erroneous in that the computer system did not show that that person would have a vote in a traditional FC and also a vote in the DC second FC. No, but people have to be issued with the ballot papers. You need to have the ballot papers issued to you at a polling station. So would somebody actually get 4 ballot papers? That would be impossible. Right, I think Mr. Chung should go back and check with his friends. Is it that he really got 4 ballot papers at the polling station? First of all, the computer system should be able to show this. If he has a vote from the DC second FC and also a professional vote, then he should be shown to be so. And also at the polling station, the staff should have been trained that nobody should be issued with more than 3 ballot papers. I think if somebody got 4 ballot papers, then there must be a problem with the training of the polling station staff. Well, actually, corporate votes must be cast at a certain place, but then DC second FC or traditional FC and GC votes are also cast at the same station. I think there must have been a problem somewhere. Sorry, Ms. Ho, please continue. Right, I think we have the same view, Chairman. I think there was an operational problem. Mr. Chung, please do dig up that case and ask whether your friend was actually able to cast 4 votes. If that's the case, then there must have been a grave problem with the training of polling staff. And even if somebody was able to register instead of also having 4 ballot papers issued, then there would still be a problem with your computer system. Mr. Lee, can you let us know more about your computer system? Will somebody be identified if he indeed belongs to 2 FCs? But I have 2 other questions, Chairman. Number 1. In the last VR exercise, you asked all GC voters whether they would want to be a member of the DC second FC. I don't know whether those, with regard to those who have just become 18, what happens to their registration form? Is it that they would be able to tick a box already, or do they have to fill out 2 registration forms? It would be more desirable if this was done on 1 registration form because it would be less wasteful. Second question, we would not stop people from making a choice from time to time. If somebody is in a traditional FC, but he doesn't want it anymore, because in a traditional FC, there would just be hundreds or thousands of votes. I like to switch to the DC second FC, or the other way around, for that matter. He might have voted in the first DC second FC election, and then he thought that the results was not what he wanted to see, so he wants to switch back to the traditional FC. What procedures can be followed in order to do that switch? Is it that they have to do so at the VR exercise every year, or they can do so at any time at all during the year? Mr. Lee. Chairman, I'll ask the last two questions first. If it is a newly registered voter, if he wants to be a DC second FC voter, he just has to fill out one form. That form provides the choices. If he says he doesn't want to be a DC second FC elector, then he can check a box, so he will not be registered as a voter of DC second FC. Another question, if somebody wants to switch from a traditional FC to the DC second FC, or the other way around, we call this the some amendment to his registered particulars. It will be akin to a new registration. If it is a non-election year, non-DC election year, the deadline is the 19th of June. As long as he supplies the relevant registration form before that deadline, that can be done. Say, for example, he has been a DC second FC elector, but now he has become a lawyer, so he wants to go back to the legal sector, FC, then he can do so. As to the first question, the issue of 4 ballot papers, I'd like to make a very serious statement that under the law, anyone can at most get 3 ballot papers. It is impossible for someone to have 4 ballot papers. I think the operation is also very strict. It is impossible for somebody to be issued with 4 ballot papers. In terms of training and our control measures, it is not possible for someone to be issued with extra ballot papers. The VR is for public inspection, and on the VR, it is very clearly stated that an elector has been registered in a certain FC. Some people are not registered with any FC. Some people in traditional or others in DC second FC elections. And the same goes for the issue of ballot papers. We will do 100% checking before the register is given to polling staff for the issue of ballot papers. In terms of the issue of ballot paper procedure, there are very clear control measures. Say, for example, some people may have 1, 2, or 3 ballot papers, and those will be clipped on clipboards of different colors. So I don't think it could have been possible for someone to get 4 ballot papers. Now, would, say, 2 ballot papers be clipped together on a clipboard? That could be a human error, and I, of course, cannot say that it is not possible. But if that is the case, then you can lodge an election petition, or you can lodge a complaint there and then. I wouldn't speculate on the case cited by Mr. Chung. I would really like to have the information for follow-up. In fact, after every election, after the 2012 DC election, for example, we have received such complaints, and we have done follow-up. And if necessary, we'll refer to law enforcement agencies. So there are very specific procedures to do follow-up work. Thank you. Chairman, I am speaking in good faith. I'm sure nobody would want to be registered in more than one FC. But if someone is indeed issued with 4 poll cards and 4 ballot papers, he might not know he has broken the law. He might go to a polling station to cast a vote in GC and traditional FC, and then to another polling station to cast the professional vote. So, Mr. Lee, can you give me the information at the next meeting? And that is, in the computer system, can an error be identified? How can you prevent a situation where somebody is registered at the same time in 2 FCs, one being the DC second FC, and also at the polling station? Do the staff base their judgment on the FC register, or can poll staff actually know how many ballot papers an elector should get? If they say, I belong to the accounting constituency, and then he would present the register for accountants. Is that right? No. Let Mr. Lee explain. Indeed, Chairman, that will not happen. In the VR, you will see that there is just one entry for each elector, and next to that entry, there will be a sign stating how many ballot papers he should have. If somebody has already approached a polling station to get ballot papers, then his entry would have been deleted or crossed out, and it is not possible for him to come again to get ballot papers. This is one of the control measures. And as I said, all the VRs are exhibited for public inspection. Now, in fact, I can say with my hand on my heart that there would not be a case for people to get 4 ballot papers. We show the public all the information, and you can see how many ballot papers each elector can have, because that is in the voter register. And as for poll cards, we would also let you know whether you should get 1, 2, or 3. If somebody should get 4, I would find that very strange. But, of course, if you have specific information, we'll be very happy to do the follow-up. Mr. Kenneth Chan, Chairman. Well, yes, it's possible. If a natural person like you or me, we are authorized by certain corporates to cast a vote, Mr. Felix Chung's case can very well happen. No, 3 votes. Say if I have a vote on behalf of a trade union, then certainly. So this is not that strange. No. What he is talking about is that you have 4 ballot papers. No, I'm getting to it. Mr. Chairman, please do not disrupt me. Actually, in 2012, please look at news reports on election day and after that day, and even some people of the Civic Party had been issued ballot papers of 2 FCs, and they returned 1 to the poll staff. I think that was a procedural problem. All right? When you publicize that each person should have 2 votes, 1 GC, 1 FC, people would be sending out these ballot papers, etc. But of course, that member of the Civic Party returned 1 FC ballot paper to the staff because that would amount to a contravention of the law. Now, we don't know how many such erroneous cases happened. But of course, that should not have happened, and that is, of course, not allowed under the law. But did they happen? Yes. And I think my party member told me exactly that, and he actually told the media that you should not get more than 1 ballot paper for FCs because that would affect the fairness of the election. And you can look at the news reports on the next day. It was in the news. Well, I think that the election system is quite disappointing. As to the verification of identity of FC voters, maybe here or at the panel, I can say that it is quite passive. The administration is in a passive position. If you're a member of a certain organization or institute, and you would be given the ballot paper, and I can actually only ask the ICAC to tell you about the best practices, etc. In different FCs, we also question whether somebody is a voter. Why somebody is still a voter? Isn't that he has been a member of that organization once, he will forever be regarded as a voter of that FC.
If the government still has this condoning attitude, then in any constituency, especially where you have a small constituency, only 100-odd voters, they don't have business, they are voters, it gives people the impression whether they are vote rigging, vote fixing, or is it a historical problem? So, will the government conduct a physical check of all these FCs in the upcoming elections? Otherwise, how can we handle these complaints? If there are no complaints, then you assume everything is working. So can you ensure that when the voter, no matter whether he has 3 votes or whatever number of votes, that it's a real vote? Well, I agree that we should excise the FCs and we would be rid of all these troubles. Mr. Lee, could you clarify? Because just now you were pledging that those scenarios would not occur. Yes, we understand what Mr. Tenkalok is saying. I said that we cannot rule out 100% human error, but the law and procedure would not allow 4 votes. But if you're referring to human error, well, we will pledge that in our training we can do a better job. Second question about FC information. You understand that FC is linked to membership affiliations, and that is how we handle the voter registration. We will audit when possible, but we also have to rely on governance of the association and its membership control. That's why we have invited ICAC to do some workshop and seminars to enhancing transparency and credibility. You also need to understand that we have to rely on the governance. They have to provide information on a timely and accurate basis. So, any more follow-up? Well, I suggest that we have discussed items 1, 2, and 3, and we only have some 10-odd minutes to handle item 4. I don't think we can handle that, so perhaps we should postpone to the next meeting. The next meeting is the 31st of May. We'll have a hearing. So before a hearing, we should hold a meeting. How about Monday, 26th, 8:30 on Monday? Any problems? 26th of May, Monday, 8:30. You are aware that we're holding meetings on Monday, Tuesday, and 31st at 9 o'clock. It's not fixed. 9 to 1. If there are a lot of deputation, we'll have to consider running into the afternoon. Well, no questions. Then next meeting is 26th of May and deputation hearing, 31st of May. We will issue a notification through the internet. We'll also write to the district councils. It's related to district council. So we adjourn here. Thank you, everybody.